Уважаемые дамы и господа, уважаемые коллеги.
Ladies and gentlemen, colleagues, I'm happy to welcome you at the roundtable today. You can see that it is dedicated to trademarks, sword or shield, issues of legal practice. The roundtable is organized together with the International Chamber of Commerce, with ICC. ICC is a powerful, most respected non-commercial organization created in 1919. In the year 2000, ICC opened its office in Russia, and within the framework of ICC there is a Commission for Intellectual Property, and I chair this commission. I have the honor of chairing the commission. So today we were granted the honor to organize this roundtable discussion. I hope you all enjoy the discussion, because the topic is quite important for today, and it's not by chance that we have selected it. Lately, the trademark disputes, it's the greatest category of disputes, definitely the largest category of disputes within the Russian Court for Intellectual Property Issues. And we are planning to talk about the definitions of the boundaries, so to speak. We need to find where the boundaries are in order to understand better where the law concerning trademarks is applied justly and fairly, and where not. We all know that the trademark right is a limited monopoly, limited in time, limited territorially, and limited by the subject matter. But we can see many more cases, both in Russia and abroad, where the boundaries of the application of law are diluted. And it seems to me that our discussion today will help us to find the truth, particularly since we have a very interesting panel of speakers, and allow me to introduce them now. Here they are. I will introduce all of them one after another as they go. And we are planning to discuss the following topics. So the boundaries of the monopoly, the bad faith at registration and implementation of the right for trademark. We will speak about the well-known trademarks, because these are exclusions, and that's where the boundaries are quite wide. And the Soviet trademarks, so what can we do without them? Because since the time of the disintegration of the Soviet Union, we have gone through a lot, but the disputes concerning the Soviet trademarks are still running, and so there are very different viewpoints, quite opposing viewpoints on them. And among the speakers, you will find representatives of these different viewpoints. And let's ask our first speaker to take the floor. And it's quite proper to introduce to you a representative of the International Organization for Intellectual Property that is responsible for the administration of practically all the international agreements in the field of intellectual property. Madam Louisa van Groenen, Director of the department that is known as the Building Respect for Intellectual Property. Madam van Groenen, the floor is yours.
Good morning. Thank you very much. Thank you for the introduction. And I'm very honored to be part of this very high-level panel discussion on intellectual property rights, notably trademarks. So I have a presentation prepared. It is a bit broad. It's broader than merely the trademarks, sword or shield, because I am not from the department in WIPO which deals pertinently and directly with trademarks. The Building Respect for IP department deals really with the enforcement of intellectual property rights, and that was also previously the name of this division. Now, unfortunately, I don't have the slides in front of me, so if you don't mind that I look around from time to time.
Сейчас передо мной непосредственно, поэтому мне придется оглядываться на экран. Поскольку мы уже слышали, действительно, наша организация, Всемирная организация по интеллектуальной собственности, является глобальным форумом, который занимается вопросами интеллектуальной собственности и правом интеллектуальной собственности. У нас 188 государств-членов, и у нас наблюдается большое количество международных конвенций и договоров. Надо сказать, что работаем в весьма враждебной, многосторонней среде, и нам удалось, тем не менее, пересмотреть Лиссабонское соглашение. Действительно, это было прорывное событие, и мы очень рады, что страны-члены нашей организации пришли к согласию. Но если мы вернемся к тому подразделению, которое я представляю, это построение уважения, создание уважения. Собственно, это одна из стратегических целей нашей организации. Стратегическая цель номер 6. И здесь мы прежде всего должны подчеркнуть значимость международного сотрудничества и взаимодействия в сфере интеллектуальной собственности. И я хотела бы рассказать о нашей деятельности в этой сфере. Моя программа в том числе, мне кажется, что у меня как-то пара слайдов пропали. Но, моя программа отвечает за диалог в сфере политики в рамках работы комитета по исполнению этих положений. Это комитет очень важный, комитет, в рамках которого мы обсуждаем все наиболее важные вопросы, связанные с исполнением права на интеллектуальную собственность, с осуществлением его. И, конечно, это стратегическая программа, которая имеет номер 17. Еще одна сфера нашей деятельности заключается в том, что мы просим страны-члены подготовить законодательство, которое соответствует с части 3 соглашения ТРИПС. Как вы знаете, эта часть посвящена как раз вопросам исполнения, осуществления права на интеллектуальную собственность. Мы, кроме того, работаем над вопросами интеграции вопросов интеллектуальной собственности в различные другие сферы деятельности. На нашем веб-сайте вы найдете значительно больше информации касательно того, чем мы занимаемся в нашем отделе. Но если мы вернемся к торговым знакам, я думаю, что широко известно, что у нас в данной сфере имеются проблемы. Именно проблемы, связанные с исполнением и осуществлением права. Если мы посмотрим на решение, в том числе на решение 1842 года, когда сказал, человек не может продавать свои собственные товары пытаясь продать их как товары какого-то другого лица. И он не может использовать другие имена для того, чтобы продать свою продукцию, якобы произведенную другими лицами. И действительно, марка не может использоваться для целей обмана и введения в заблуждение. Таким образом, это проблема сегодняшнего дня также. И такого явления, как пиратство в сфере интеллектуальной собственности, эта проблема все время расширяется, и мы получаем все больше запросов от судебной власти, например, с тем, чтобы подготавливать судей, обучать их работе именно в этой сфере, для того, чтобы они могли рассматривать все более сложные вопросы, связанные с нарушением права на торговый знак. Авторское право также является очень важной темой данной дискуссии. Ну, конечно, обычные обычное нарушение права на торговую марку и фальшивая торговая марка – это очень важное различие. На самом деле обычное нарушение также достаточно для того, чтобы ввести в заблуждение обычного пользователя. И, конечно, за это требуется нести ответственность. Когда же речь ведет о фальшивых марках, то мы говорим о копиях, которые изготавливаются на коммерческой основе. Что здесь очень важно? Важно понимать, каковы определения. Важно понимать определения именно в этой сфере. Мы должны понимать, что мы говорим об одном и том же, когда мы говорим о фальшивых торговых марках и знаках, понимая, что здесь речь не идет о субстандартной продукции. И каждый раз, когда мы обсуждаем эти вопросы, нам необходимо понимать, каковы определения о торговых знаках, что такое фальшивая торговая марка и торговый знак. И здесь мы следуем статье 51, параграфу 14, и говорим о требуемых стандартах. В соглашении ТРИПС, я не буду, конечно, сейчас очень подробно говорить об этих положениях, но вы все, безусловно, знаете, что это подразумевает, каковы требования в соглашении ТРИПС в связи с мерами защиты и санкциями административного, уголовного характера. Иногда мы видим совершенно невероятные цены и невероятные результаты. И мы видим, что наши государства, члены организации, чрезвычайно озабочены именно фальшивыми марками и знаками. И неважно, о чем мы говорим. Говорим мы с вами о безопасности, о здоровье, говорим о роскоши и о предметах роскоши. И всегда мы должны думать о укреплении потенциала с точки зрения того, что мы должны получать сертификаты о происхождении продукции. Иногда мы видим совершенно явные нарушения права. Мы видим, например, веб-сайты, которые продвигают явные копии очень хорошо известных автомобилей. И мы видим, что эта деятельность все время расширяется. И хотя это незаконно, в большинстве стран продажа фальшивой продукции запрещена, мы тем не менее видим, что эта проблема все время расширяется. Если мы с вами посмотрим, например, такой веб-сайт, как fakegifts.com, вы, когда посетите этот веб-сайт, все сами увидите. И тем не менее, большой спрос наблюдается на подобного рода продукцию. Таким образом, владельцы этого веб-сайта, когда оказался в тюрьме, заявил, что даже если они закроют один сайт, я все равно создам другой сайт, потому что я прекрасно понимаю, чем я занимаюсь, но деньги столь хороши, что я буду продолжать эту деятельность и дальше. Это очень существенная проблема, и я думаю, что когда мы будем говорить о незаконной торговле, мы все равно вернемся к этому вопросу. И вернемся к вопросу доходов от незаконной деятельности, к вопросу о том, каким образом сделать все для того, чтобы стимулы для осуществления подобной деятельности исчезли. Но возникает такой вопрос. Почему? Почему имеется спрос на такую продукцию? Я могу предложить вам поговорить об исследовании Бейскет. Это часть работы ICC, и мы здесь увидим с вами причины представленные. Я вам представляю здесь некоторые из наиболее важных причин, по которым потребители пользуются подобного рода продукцией, такими товарами. Вы, конечно, понимаете, что, конечно, здесь есть вопросы цены, доступности, доступности этих товаров с точки зрения финансовой и других. Если вы посмотрите на основные факторы, которые мешают приобретать эту продукцию, видите, что вопросы здоровья и безопасности являются очень важными для пользователей, для потребителей. И, безусловно, вы можете также столкнуться с проблемами законодательства. Такие противозаконные действия являются преградой. Безусловно, когда речь идет о том, что неизбежно наказание, неизбежно преследование за подобные действия, тогда легче решать проблемы. Что касается комитета по исполнению, на самом деле данный комитет, это консультативный комитет, отвечает за глобальные вопросы, связанные с определенными целями, поставленными в нашей работе. Но, кроме того, важно подчеркнуть, что данный мандат действует одновременно с рекомендацией 45 повестки дня WIPO. И цель состоит в том, чтобы достичь баланса между частным правом и общественным интересом. И значительно больше информации относительно данного вопроса вы найдете на нашем веб-сайте. Некоторые сессии нашего комитета, консультативного комитета, могут быть для вас интересными. Я здесь перечисляю те темы, которые мы обсуждали на заседаниях нашего комитета. Вы видите, что некоторые сессии были посвящены судебным, уголовным процедурам и другим вопросам подобного характера. Когда члены WIPO приняли программу и повестку дня, мы увидели значительное изменение в осуществлении права на интеллектуальную собственность. И мы таким образом видим, что от исполнения мы можем продвигаться к созданию системы, основанной на уважении. Собственно, в этом цель работы нашего комитета. Мы начали продвижение этого явления. Мы начали также думать о том, что мы можем сделать для того, чтобы предупреждать нарушение прав интеллектуальной собственности. Если мы не понимаем мотивацию, которая стоит за нарушением прав, если мы не понимаем, каково восприятие пользователя и потребителя, может быть, нам нужно найти другие бизнес-модели, может быть, надо поискать альтернативные пути распространения товаров, которые защищены правом на интеллектуальную собственность, для того, чтобы противостоять изготовлению фальшивых товаров и пиратству. Конечно, времени у меня очень мало, но еще раз я хочу напомнить вам, что вы найдете значительно больший объем информации на нашем веб-сайте. Мы в настоящее время продолжаем работу по двум вопросам в рамках нашего консультативного комитета. Во-первых, мы ищем возможности при использовании системы альтернативных путей разрешения споров, а также мы изучаем профилактические меры, изучаем успешный опыт для того, чтобы можно было дополнить существующие меры. Наше следующее заседание состоится в ноябре. Я уже говорила о международном сотрудничестве, и в том числе, конечно, надо помнить о возможности сотрудничества в рамках Международного конгресса. У нас проводятся заседания, посвященные работе в частном секторе, работе в WIPO и Интерпола.
Мы ведем очень тесное сотрудничество, которое очень важно для нас. Это то, где судебные органы могут внести важный вклад, а именно в том, что касается уничтожения контрафактной продукции. Мы начали работать вместе с экологической программой ООН, и в рамках рамках сотрудничества судей мира мы добиваемся понимания необходимости издания соответствующих ордеров и приказов на уничтожение контрафактной продукции. Еще один важный вопрос, который необходимо поднять, и вы найдете более подробно о нем информацию на нашем сайте ВАИС. В начале года состоялся семинар, посвященный интеллектуальной собственности и частному международному праву вместе с Международной правовой ассоциацией. Мы затронули очень важные вопросы судебного рассмотрения. Подробная информация на нашем веб-сайте. А сейчас мне хотелось бы дать вам некоторую статистику о нашей деятельности во многих странах мира. И мы готовы и хотели бы рассматривать различные предложения о том, что касается развития нашего потенциала. Наши сотрудники, коллеги в судейском корпусе получают возможность решать соответствующие вопросы в своих судах. У нас есть специальные публикации на английском языке, на французском, арабском и испанском, касающиеся деятельности ВАИС. Насколько я понимаю, перевод был также осуществлен на китайский язык. Мы готовы работать с российскими органами власти, оказывая содействие переводу на русский язык. В завершение хочу заметить, что невозможно соблюдать права интеллектуальной собственности и менять отношения потребителей, если мы не будем работать с ними теснее. У нас используется стратегический подход к информированию и формированию понимания у населения значения интеллектуальной собственности для того, чтобы обеспечить уважение к правам интеллектуальной собственности. У нас есть специальные механизмы взаимодействия. Мы можем содействовать этой работе в странах-членах нашей организации. И мы также мы представим на рассмотрение нашего консультативного комитета программу по работе с детьми. Понятно, что нужно работать с молодежью, потому что проще менять поведение среди молодых, нежели воздействовать на людей моего возраста. И в завершение хочу сказать, у нас есть специальная программа наград ВАИС, которая очень широко используется, в том числе и в вашем регионе, чтобы стимулировать инновации и творчество. И мы готовы работать с российским правительством в том, что касается присвоения наших наград и медалей заслуженным претендентам. Большое спасибо за предоставленную возможность. Готовы ответить на вопросы, если они у вас возникнут, может быть, позже.
Спасибо, госпожа Ван Гройнен, за тот международный аспект, который вы привнесли в наше обсуждение. Я думаю, что для оптимизации нашего круглого стола мы оставим вопросы на конец обсуждения. А сейчас мы перейдем к следующей части. Поскольку мы говорим о правоприменении, невозможно говорить о правоприменении без тех людей, которые каждый день это правоприменение осуществляют. И нам очень повезло, у нас следующая группа выступающих – это судьи. Людмила Александровна Новosiolova, председатель суда по интеллектуальным правам, которая на самом деле является комодератором, но мы решили, что гораздо будет всем интереснее, если она будет выполнять именно не функции модератора, а выступит. После нее будет выступать господин Шон, судья земельного суда города Мюнхена, и потом господин Алан Жерардо, судья Кассационного суда Французской Республики. То есть все судьи профессиональные, постоянно занимающиеся вопросами интеллектуальной собственности. Так что мы сейчас узнаем, как в разных странах правоприменительная практика относится к вопросам товарных знаков и к той теме, которая задана нашим обсуждением. Людмила Александровна, вам начинать.
уважаемые коллеги, я очень рада возможности в рамках Международного питерского форума обсудить вопросы с нашей точки зрения исключительно актуальные, связанные с злоупотреблением при использовании, при регистрации товарных знаков. Мы только сейчас, наверное, начали по-настоящему понимать, насколько ценным активом является хорошее коммерческое обозначение, средство индивидуализации, товарный знак, насколько дорого он стоит. И то, что это стало пониматься, привело к резкому увеличению споров, связанных как с защитой прав на товарные знаки, так и со спорами, которые связаны с предоставлением правовой охраны такого рода средством индивидуализации. И в рамках рассмотрения такой категории дел, таких категорий дел, мы можем вычленить целый ряд случаев, когда право на товарный знак используется в противоречии со своим назначением, когда право на товарный знак начинает использоваться для того, чтобы ущемлять конкурентов, для того, чтобы использовать, в частности, чужие узнаваемые обозначения. При применении российского законодательства мы прежде всего руководствуемся положениями Гражданского кодекса, которые позволяют признать недействительной, оспорить регистрацию товарного знака в том случае, если было признано, что при регистрации товарного знака правообладатель злоупотреблял правом, либо допускал действия, которые можно квалифицировать как недобросовестная конкуренция. Речь идет о
of faith. We're talking here about Articles 15 and 12 of the Civil Code. When we apply this article, issues of qualification of the actions made by this or other person as bad faith could be recognized as bad faith in the administrative procedure. And you know that the functions of the Federal Anti-Monopoly Service in that area relates to the analysis of the markets and to the analysis of the actions by these or other entities in registration of their trademarks and qualifying them as bad faith. So there are certain options for the administrative procedure. As for the assessment of the actions by the Federal Anti-Monopoly Service, disputed in courts as well. There may be not many of such cases, but in importance, these cases are of particular public interest, they're high profile, all of them are well known. As for those who deal with trademark, I could refer you to one of the recent cases that was taken by the Intellectual Property Court. It had to do with the decision of the Federal Monopoly Service vis-à-vis Sayana trademark, whereby it was sought to recognize the actions of one of the Russian corporates as bad faith competition, whereby this actor registered the Soviet, or formerly Soviet trademark as their proprietary trademark. It was disputed, but the Federal Anti-Monopoly Service ruled it was bad faith. However, the court did not agree with the Federal Anti-Monopoly Service, and I would explain later on where we have ways to dispute the actions of the Federal Anti-Monopoly Service.
Прежде чем перейти вот как к
Before
негативной оценке,
I talk about the negative
характеризовать те случаи, когда суд не согласился с антимонопольным органом, я хотела бы, тем не менее, сначала рассказать о том, в каких случаях суд признает правомерность действия антимонопольного органа и его решений, и какими критериями мы при этом руководствуемся. В качестве такого базового спора, на котором, наверное, можно рассмотреть рассмотреть те подходы,
cases
которые
that would be very
применимы при такого рода делах, я хотела
for
бы
this
привести
category of
дело
cases. I want to refer
с
you
обозначением товарным знаком
to
«Вермонт»
the Vermont
для тех, кто
trademark
не является постоянным
those of
посетителем
you
цветочных магазинов
who
и
do not
магазинов,
buy
в
a
которых
lot of
продаются аксессуары.
flowers,
Я
don't go to
хотела
accessory
сказать о том, что
shops.
крупная
Let me
международная
remind
компания,
you, there's a
по-моему,
big
местонахождение в Канаде,
international company, I think they're based
регистрации,
in Canada,
является крупным производителем
and
сухих
they
цветов и композиции из цветов.
produce a lot
Товарный знак
of
«Вермонт» очень
flower-related goods, and their
такой узнаваемый
trademark
товарный знак,
Vermont is
изображает из себя
quite common,
ворота
well
усадьбы,
recognized,
как
showing
было
gates to a manor house.
сказано в рамках этого
And as
обсуждения,
it was
почему такой
explained
товарный знак,
during
что это
the
ворота усадьбы
Chadecation, well,
владельца
these
фирмы,
gates were actually the gates
этого
of the
бизнеса.
founder of
Ну и,
the
соответственно,
Vermont
обозначение
company.
Вермонт — это
So
фамилия
the Vermont
основателя
refers
фирмы.
to the name of
Длительное
the
время эта компания
proprietor. For a long
ввозила на
time,
территорию Российской
this company
Федерации
was
свою
quite active on the
продукцию через
Russian
дистрибьютора,
markets. They were
которому в
distributing
соответствии с
their
договором было
goods through a
запрещено регистрировать за собой
distributor, and the
аналогичное
distributor was
обозначение.
not allowed to
Но
register the relevant
спустя какое-то
mark
время российский дистрибьютор
to its
посчитал,
name. But
что
sometime later, this Russian
договорные
distributor
отношения
thought
в какой-то момент прекратились,
that
обозначение
there was no
вполне
longer an
узнаваемое на рынке,
contract.
уже все потребители
Everybody
это
knew by that
обозначение
time the mark.
связывают
It was
с
well
определенным
recognized.
производителем,
It was
определенное качество
associated
товара,
with
которое
certain
обеспечивается в
quality
этом
of
случае,
goods,
позволяет ему,
producer,
использовав репутацию
and
указанного
relying
товарного
on the
знака,
reputation
благополучно
of the
самому войти на
trademark, the
российский рынок.
distributor
И
thought
было
they
зарегистрировано
could
в
do good
России
job in Russian
практически
markets.
аналогичное
So
изображение.
what they did, they
В данном случае,
registered a
когда мы
very
говорим о том,
similar,
что имело
almost
место сходство до степени
identical
смешения,
mark.
в
This
данном
was
случае можно было бы говорить даже о том,
exactly the
что товарный
case
знак был
of
практически
the
тождественен тому, который
confusingly
использовался до
similar
этого
or even
иностранным
identical
правообладателем.
trademark that
Вот
belongs to
ситуация,
foreign
в которой возник вопрос, как квалифицировать действия
So the
лица,
court was
которое
to
на территории
qualify
Российской
the
Федерации
actions of the
зарегистрировало знак,
person that
который
had
до этого
registered
использовался
a trademark
на
that
нашей
used to
территории
be
иным лицом, приобрел
current
очень широкую известность
in
для
Russia
определенного
and
вида
used
товаров,
to be
и,
associated
соответственно,
with
лицо
another
знало об этом,
company,
не могло не знать
the
в силу того, что само
entity that
продвигало
registered
эти
the
товары на
trademark
нашем
couldn't
рынке, но
possibly not know
действуя в
about
свое
that
время
because they
по
used to
поручению
distribute
правообладателя.
the
Вот в
goods, but
данном
they were
случае,
acting
когда суд
formally
анализировал
under the
этот
contract of the
спор,
IP
то здесь два момента
holder.
имели значение. Первое – это
What was
узнаваемость
important for
этого
this dispute
товарного
was
знака. Естественно, в данном случае мы видим, что это фантазийный товарный знак, который действительно потребителями очень четко выделяется. И в данном случае все практически субъекты, которые сталкиваются с таким товаром, обозначенным с использованием аналогичного средства обозначения, они полагаются на репутацию соответствующего производителя. Узнаваемость прежде всего, ну и второе, что совершенно очевидно в этом случае, это намеренные действия, которые направлены в ущерб интересам правообладателя. И мы не можем этого не видеть по той ситуации, которая складывалась, поскольку лицо ранее не могло само использовать этот товарный знак, оно продвигало его как чужой товарный знак, и регистрация имела целью воспользоваться репутацией чужой. Цель совершенно четкая, совершенно ясная, цель направленная на то, чтобы вытеснить предшествующего субъекта с рынка. Это было видно также и по последующим действиям соответствующего нашего российского правообладателя, поскольку после регистрации он стал предпринимать активные действия по запрету ввоза определенной продукции на российский рынок оригинальному правообладателю. И предпринимал очень активные действия для того, чтобы поставить границу для ввоза товаров оригинального производителя. Совокупность вот этих вот действий дала возможность квалифицировать действия компании, зарегистрировавшей на территории Российской Федерации товарный
actions of such distributor vis-à-vis the Vermont trademark as actions that should be qualified under Article 10 of the Paris Convention, which is bad faith competition, and we could thus uphold the validity of the dispute against this distributor and the registration of the trademark at Rospatент. So this is the case where we see the two important qualifying properties that could lead us to the qualification of the so-called parasitic competition. It is the use of a recognized trademark and an attempt to piggyback, to rely on the existing trademark, which has been well promoted, well recognized, to the detriment and prejudice of the original IP holder and the one who initially created the trademark. So when you assess the circumstances of the trademark registration, you need to make sure that faith was there in place when the registration happened, when the application for registration happened. Since this application had a fixed date, to find out the intent of the applicant, can rely on the actions taken by that particular applicant before and after the registration. So how could you go about assessing the actions taken prior to registration? In this kind of disputes, we see situations whereby several entities, several persons can be using the same mark. All of them were involved in the promotion of that trademark, but one of those entities at one point in time applies for the registration of the trademark, while by others, for some reasons known to them, do not apply for registration. Would this behavior mean a priori that one of these entities could be acting in bad faith? Probably not on the face of it. You can't assert that by applying for registration, the entity was acting in bad faith. To say it was bad faith, we need to assess the intent, whether there was an intent to infringe on the rights of other IP holders, or this may not happen either because the applicant may not know about the existing trademarks. But if this person was knowledgeable about the competing trademarks, about the existing trademarks and about the competition on the market, they still insist on getting it registered. There's better chance that his actions, their actions will be deemed bad faith. I can refer to the case we had recently, whereby the court ruled some bad faith actions taken by one of the applicants registering a trademark. Well, the circumstances were quite common. The trademark was used by several entities, and after one of the two competitors on the market increased their sales dramatically. They improved their position significantly. The other one, who was using or relying on a similar trademark, decided to register the trademark. So for the court, it was important to look into the dynamics. They were competing for a long time on the market. They were not doing anything against each other. But when one of them started increasing their sales, the other one thought it would be a good way to stop the success of the competitors. They couldn't increase their own sales, but to stop and bar the other more successful competitor, they decided to register the trademark to their name and thus rely on their trademark rights and bar the competitor from the market. So this particular circumstance was the main reason for the court to rule the registration was a bad faith competition. assessment of the actions after registration could also help, and we could refer to one of the cases which was quite graphic, illustrative, and I always like to tell about this.
И товарный знак узнаваемый, ну, я не знаю.
Because the trademark is quite easily recognizable. The young people in particular recognize it easily. So it's the trademark of Monster Energy. Monster, that's the trademark. I'm talking about the young people because these are the energy drinks, and the trademark represents the claw marks on black background, and this trademark has belonged to the Monster Energy for quite a long time, the Russian market among other markets, and quite unexpectedly it became clear that at the Russian market there is another producer of a similar product, the same type of drinks, a company registered in one of the smaller cities of the Russian Federation, registered as in the name of Bitovik, and that was a transport company. Bitovik registered its trademark, the trademark that contains this particular image of claw marks on the against the black background, and our Russian right holder tried to assure us that that was their designer, and just the designer who invented that particular mark. But if we compare the two images, we can see quite obviously that this could not be just by chance. It's impossible to repeat someone else's trademark with that much detail by chance. We were also impressed by the fact that the designer of the Russian company, when creating this trademark, used the color, which is exactly the color of the original trademark. So we were really surprised with that. How is it possible to recreate the color that exactly without knowing that there is another image of a similar type? So assessing the registration possibility for this particular mark, we first of all considered the awareness of the original trademark, mostly known due to the American producer of that commodity, the fact that it is easily recognizable, an obvious attempt to reproduce this trademark, which is of a secondary character. And then after the emergence of the conflict, the Russian right holder not only did not continue the promotion of the trademark, but actually tried to register some other trademarks, the trademarks which were hardly different at all from some other trademarks. While previously he was trying to register certain differences, eyes and claws. If the eyes were added, he believed that that changed the whole situation radically. But at a later stage, the Russian company decided that even those small details were not needed and applied for the registration of absolutely similar trademarks, which indicates that he not only understands what he is doing, but actually intends to try to combat the original producer at this particular market. Anyway, we can see that the actions at the market of trademarks can quite often be in bad faith. And what can we do against that? There are possibilities and opportunities. We can dispute the registration through the anti-monopoly agency. We can do it through the court procedures. And this issue of bad faith at registration can be raised within the framework of a different case. For example, when disputing the actions of Rospatent that denies the application against that new trademark. Court, first of all, considers the Russian Civil Code provisions and applies Article 10 bis of the Paris Convention. Now, it is very difficult to provide you with the full statistics. Technically, it's difficult. This system does not make it possible to have the count of all the cases when the courts apply the provisions of the respective convention, and particularly Article 10 of the Civil Code, abuse of right. But nonetheless, we tried to make some calculations manually, so to speak. So I can't say these are official figures, but nonetheless, the non-official statistics indicates that in 70 cases, the courts applied in the for intellectual property courts. So that's the court itself applied provisions of Article 10 of the Civil Code. And there are 90 cases when Article bis of the Paris Convention was applied on the merits. Now, as for the overall number of cases, multiplied by 3. So altogether, 260 cases when the articles applied, the Article bis of the Paris Convention. So you can see that this article is quite extensively used in the practice of the Russian courts. And finally, I would like to address the audience, most respected audience, understanding that here among you there are representatives of business community, and say that it seems to me that the protection of the trademark rights is extremely important nowadays, so much so that we need to discuss these matters extensively, and the number of persons involved into the discussion should be extended. We should go beyond the professional community in these discussions. We understand that tomorrow this issue is going to touch upon the interests of every entrepreneur. We don't want the decisions to be made spontaneously without considering the needs of our market. And first and foremost, I talk here about the attempts made to expand the competences of the Federal Anti-Monopoly Agency. Not just through the expansion of the competences as such, but through the amendment of the legislation that would make it possible to introduce a large number of cases that can be qualified as bad faith competition. Why am I concerned with that? Well, when there are attempts to change the legislation, sometimes we forget that the right for a trademark is a monopoly, a legal monopoly, and this it is necessary to understand where this legal monopoly exists and in what cases the right holder has the right to protect this monopoly using the whole range of defenses, and where there is a true case of bad faith behavior. Since this boundary today is not clearly delineated, I think it is too early to incorporate into legislation provisions that have not been tested by practice. Now, I have come to the end of my presentation. Thank you very much for your attention. Thank you, Ludmila Alexandrovna. And now we would like to listen to the European practice, and allow me to give the floor to Dr. Sean.
Oliver Schön. I'm a judge from District Court Munich. First of all, I'd like to thank President Novosiolova and Mr. Arievich to have the chance to speak here. I like to send best regards from all my colleagues. Everybody's very interested to learn about the Russian situation. And when I was invited to speak here, actually I discussed with my colleagues how to or what to present here. And we thought that it might be best idea to present one case example where a German court cancelled a registration because of bad faith, but in a not famous trademark. First of all, I like to give you the information that we do not handle many bad faith registration cases in our court, and we were actually discussing what are the reasons that we do not have many cases? And most probably there are two reasons. The first one might be that we have very clear and predictable standards, and even despite the fact that you always have to consider all circumstances, it's very clear because the Supreme Court gave clear rules. I will explain it to you later. And the second reason might be that absolute ground, that bad faith registration is an absolute ground of refusal in Germany. I like to give you, in the beginning, some comments about the general setting before I introduce this case. It might be interesting to you to learn how the relation between trademark law and unfair competition law is seen in Germany. And our Supreme Court says that both laws exist side by side, but the trademark law is a special law, and therefore the unfair competition law cannot be used to bypass any meaning of the trademark law. So when you talk about unfair competition, you have to ask firstly if trademark law does cover any aspect of unfair competition, and especially impediment competition when you talk about bad faith. And actually trademark law has only one provision concerning impediment competition. It's the handling of a trademark by an agent, which is not the case in our case. So it means that the trademark law does not block access to unfair competition law, so you can use the regulations of unfair competition law to ask for nullification of a bad faith trademark. Actually, there are two different jurisdictions concerning a trademark which has been registered in bad faith. You can start an opposition at the German Patent and Trademark Office, and if this opposition will not be successful, you can go to the Federal Patent Court, or you can go to our court, to the normal civil courts, and ask, because it's a contradictory proceeding, the person who has registered the right to get permission to cancel the trademark in the register. That's the cases that we handle at the Munich District Court. The German Supreme Court said that there are mainly three different groups where a trademark can be cancelled because of a bad faith registration based on unfair competition law. The three groups are basically, the first group is that somebody has already received something which is worth of protection, an ownership worth of protection, and the registration is mainly done to prevent the person who has already received this ownership worth of protection from using it. The second group is that the registration of the trademark is done in order to prevent competition, especially if it aims another person from using it. And the third group is not actually happening very often. It might apply if somebody is registering many trademarks for many various goods and services without any intention of using it. So this is very theoretical, so I like to give you the case example. It's called academics case, and I like to give you some facts. I hope that they're easy to understand. So the plaintiff is a US company and the defendant is a German company. Both companies are specialized in sale and resale of urban streetwear or hip-hop fashion. I'm not sure if you have some image when you talk about hip-hop fashion. It means clothes basically for skater or young people. So what happened actually, in 1999, the American company registered a trademark, academics, in a very unusual spelling in the United States of America. And they were quite late in Europe. In 2002, they registered in OHIM, and in 2003, they registered in Germany. The German company was founded in September 2002, and they were much quicker, so they registered trademark academics in October 2000 for close, basically. So in our case, the US company came to our court about 10 years ago, and they asked the German company to give permission that the registered trademark, which was filed in October 2000, to give permission to cancel it. And they also said that the goods that the German company is selling are an infringing of the trademark of the US company. And they wanted to have some information because they want to get damages in the future. And they gave the reasons that the registration of the German trademark by the German company was in bad faith. Because academics started to sell this hip-hop fashion in 1999, and they had a very successful spring collection in 2000. And so they said the German company registered the trademark in autumn of 2000 in order to block the access for the US company. But academics started to sell products in Germany by 2003. And they also said it's very usual for a US brand who's selling clothes to start building up a trademark, a brand in the United States of America, and for the case that it gets successful, to go to Europe and especially to Germany because it's the biggest market in Europe. And the defendant, of course, said they did not know about the US trademark, and it's not obvious that a US company who gets successful in the US will start sales in Europe. And there was another point that I would like to mention because it's important. Clothes that were sold by the defendant, by the German company, actually copied stylistic features of the US company. So this case came to our court, district court, and the first instance decided that this bad faith registration and that this trademark has to be cancelled. But it came to the Court of Appeal, and the Court of Appeal overruled the first instance decision, and they applied these two first groups that I mentioned beforehand. They said Group 1 did not apply, because for Group 1 it's necessary that the US company would have received an ownership worth of protection in Germany, and there's no evidence that this actually happened, because there was no sale activity in autumn 2000, and there was no outstanding reputation in the United States of America, which could give some ownership worth of protection in Germany. And Group 2 actually would not apply, because first of all, there's no evidence that the German company knew about the registered trademark in the United States of America. It's not obvious that this US company would start sales activities in Europe later on. And yeah, that's basically the reasons. And because of that, the registration in Germany has to be accepted, because trademark law is based on two principles. It's principle of territory and priority. And if you come too late to some territory, you don't have any right. So it came to the Supreme Court, and the Supreme Court made a very clear decision. They gave some rules. Unfortunately, they were not able to decide, because our Supreme Court only handles matter of law and no matter of fact, so they sent it actually back to the Court of Appeal, but they gave very clear guidelines. And they checked these two groups actually, and they said the first group needs that the US company has received already an ownership worth of protection. So the Supreme Court said an ownership worth of protection can be enough for an ownership worth of protection if a trademark or some sales activities get very well known, even in a foreign state, so that experts in this field already know it. But in our case, there was not enough evidence that experts for hip-hop fashion would know the trademark academics in October 2000. So group 1 would not apply, but there are some rules how to handle it. So, but the German Supreme Court said that most probably group 2 would apply, that the registration is done in order to prevent competition, and they gave some reasons. And now it comes to the part which I like most. The Supreme Court said if the defendant, the German company, is saying that they did not know about the registration of the trademark in the United States of America, it's totally unrealistic. Because the spelling of the word academics is so unusual that it's just, you cannot believe it if they say they did not know it. And the German Supreme Court also said that it's kind of usual for, especially in this fashion business, that a company who gets successful in the United States of America will start business activities in Europe or foreign countries later. So the German company should have considered that they may block access to the German market. And now it comes to intention, because the defendant said, we are using actually the trademark academics to sell products. And if you use the trademark which you have registered, it's always a good indicator that you have no bad faith when you register it. But the German Supreme Court said, in this case, this does not apply. There's a little story in this case that I would like to mention. When Academics US came to Germany, the German company offered to work as an agent. So they said, I have already registered this trademark, I want to work as an agent. But the Supreme Court said, this fact cannot be used against the German company, because you have to consider bad faith at the time of registration. So you cannot take any things that happen 3 years later to indicate the intention at the time of registration. But the German Supreme Court said, in our case, intention of bad faith is obvious because the German company also uses stylistic features of the US company for the clothes that they sell under the name academics. So in this case, it's pretty clear that there's bad faith intention at the time of registration. So most of this case was sent back to the Court of Appeal, and actually most probably they settled. And the decision would be that the German company have to give permission to cancel the trademark from the German register. There would be an infringement of the US, the trademark in Germany by the US company, by the products that are sold by the German company, and they would have to pay damages. In order to summarize this case, you will see in Germany legal requirements are quite clear. The biggest problems come with evidence questions, how to show intention at the time of registration, because when you handle a court case, many years normally have already passed. Thank you very much.
Большое спасибо, доктор.
Thank you very much, Dr. Schön. I would like to give the floor to Alain Jardot, Judge in the Court of Cassation of the French Republic. Monsieur Jardot, you have the floor.
Bien. Merci, Monsieur le Président. Permettez-moi de m'exprimer en français. D'abord, je voudrais remercier les organisateurs de cette important événement, très important événement.
I'd like to thank the organizers for the invitation to speak to this very representative forum. This forum allows legal academics from different countries to discuss their opinions of various issues of enforcement and other issues of law. This is exactly the forum and type of debates that might lead us to the truth and respect the rights and individual obligations. And this brings us directly to the topic to discuss trademarks, shield or sword. And of course, trademarks is a sword because it's monopoly, but it's also a shield because it gives protection. It gives protection that may take different shapes or forms, but of course primarily the form of competition and free entrepreneurship and an opportunity to dispute rights to trademark. The right to trademark is borders on other rights. It should combine, it should be discussed in the context of other rights. And this is something I wanted to discuss with you. Let us talk about the most recent trends in enforcement, both in Europe and in France. First and foremost, I would like to draw your attention to the fact that the empire of trademarks is expanding all the time. And we are part of this huge trademark empire. And more and more often we see the growing number of disputes relating to packages, labels and logos, something that we could feel or see. Everything can become a trademark, and it's important for judges to be aware, to know when trademarks apply and whether we deal with a new trademark, because this monopoly, the trademark monopoly, is very attractive for the corporates, for the business, and the business corporates want to register everything and anything that has to do with its goods. There's another trend which has to do with the status of the common or famous trademarks. You know that well-known trademarks are very well protected, and this protection is stronger, much stronger than just simple registration of a trademark. This protection is extremely strong and sound, particularly in France and all across Europe. And just to refer you to the three important conditions protecting a well-known trademark. First is it's enough to prove that this trademark is known to a great majority of the population, and the goods are well known to the great majority in the population. The second condition is that this awareness of the trademark can be limited to one specific jurisdiction, one specific country, and this trademark does not have to be known across the border, but a trademark will still be recognized as well-known all across the European Union. And the third condition is that the protection of this well-known trademark has to do with the link between the consumer and the new trademark, which may be based on the old trademark. This new trademark, provided it is associated with the old trademark, with the previous trademark, would be good protection to this very fact would be good protection to this new trademark. It doesn't have to be that we see certain damage or detriment done to the old trademark. I could refer to the case taken by the European Court in 2008. Another case is the Royal Shakespeare trademark, and they argued that no damage was done to this trademark. I don't want to talk about well-known or famous trademarks only. What I'm saying is this recognition test is a very good protection, and this is a very strong shield that the trademark offers. This is the shield that protects you from piracy or counterfeiting, and some of the most recent precedents confirm that. However, the enforcement precedents of the past 30 years lead us to believe that we must put certain boundaries to trademarks. The trademark can be a monopoly, but this monopoly must coexist with free competition and free entrepreneurship. So, given that, courts should be advised to remember that. There are certain principles and functions that make up for this legal protection, and they are all important. In other words, the question is, what is the essence of the trademark? What is the purpose of the trademark, and who can benefit from the trademark? And the French enforcement practices seem to suggest that the key function of the trademark is to allow the consumer to recognize, to be aware of the service of the goods and be sure of the quality of the service and of the goods. So we're talking here about the consumer-centered approach. But on the other hand, and this is something our courts also look into, we talk here about certain safeguards to the interests of the IP holder. We should remember about these interests. Some most recent awards by the European Court seem to suggest that we need to forget, we need not. We must remember the promotion functions, the awareness function. Take, for example, the recent 2010 decision vis-à-vis Google company, and in 2011, in September, the Interflora decision referred to the awareness function. The trademark owner could always dispute the use of another trademark only, and if only if the other trademark goes against these two important functions. However, there are other functions. For example, there is a function that has to do with the limitations across the European Union or in a specific country, whereby the trademark protection expires. There's another aspect which has to do with the vacancy of the trademark. Take, for example, Adidas. We're all very well aware of the sports clothing and the three bars that explain or describe the logo of Adidas. However, Adidas sued a company that's produced sporting clothes with two bars because they claimed it could be associated with Adidas, and it was proved, however, that it was nothing but a decorative element. These two bars were not registered as a trademark. This designation was vacant, was free on the market. It could not be associated with Adidas. So from the point of view of the consumer, there was no association with the Adidas trademark. So the trademark rights is a powerful instrument, powerful weapon. However, if it is a powerful weapon, can it be undermined by the facts of the growing number of counterfeits? And of course, we're all victimized by these counterfeiting, us as consumers and us as producers. My colleague from Russia talked about that very graphically. So the question is then, how could we combat infringements and counterfeiting? One consideration which is important is that the trademark rights is owns the ownership to a certain symbol. First in, first out is the principle, I think, here. So, of course, it should be executed in a legal way, and our courts have been busy trying to establish whether the trademark in question was well recognized, famous, and even if we rely on Article 6 of the Paris Convention and the WIPO Treaty, paragraph 2, we need to find out whether the provisions are sufficient and whether they allow the IP holder to sue against the registration of some other trademark. The fact of recognition and the fame of the trademark would allow you to do that, because in this particular case, the court will always single out the fact that the goods or service are identical or similar to the well-known trademark.
Notoire peut être opposé à une marque déposée dans une spécialité différente, totalement.
The claim against the registration of the similar trademark in a different sector. Now, in this case, the courts quite often take the side of the right holder of the well-known trademark, applying the famous Latin phrase "Fraus omnia corrumpit." Now, allow me to add to this that the right holder of the registered trademark can combat counterfeiting using a wide range of different measures, remedies. Our enforcement practice allows that, and there are different situations here that are varied, and these instruments make it possible for the right holder to protect its rights. And those who register the new trademark can also find protection. And here we first of all have to consider the infringement, the damage inflicted on the well-known trademark. Well, of course, there is an attempt to register a trademark that is quite similar. There is a problem, and we must think of how to bypass this situation. And then there are situations when some try to jump over others in the competition, registering the trademark and taking the position of a monopoly in the market. In order to combat counterfeiting. It is necessary to prove that the individual is well familiar with the facts and the situation, and our court went even further with that. We believe that if the individual knows just the plans and the projects of the competitor, that's already a sign of fraudulent action and bad faith action. So again, situations here can be quite different, and our cassation court quite recently made a number of interesting decisions which concern exactly this type of situations, and we were able to say that there was a damage inflicted on the right holder of a well-known trademark, and it was taken into consideration that the interests of the right holder were violated and abused. And so that's just one example, because there is a lot of examples being given. But Paris, as well as other capitals, was a candidate for the Olympic Games hosting, although we lost. And even before the procedure began, before we were promoted, before the decision was made, there was an attempt to register, not, of course, of the Olympic symbol, the 5 crossing rings, but a logo with words Paris 2012. And so those were people who assumed that Paris would be elected as the host city for the Olympic Games of 2012 and tried to register this particular trademark, Paris 2012. In order to be able to say that we are the owners of the trademark, we ruled that there was a fraudulent attempt. Well, of course, when was that? That was 4 years prior to the Olympic Games. So actually it was in 1999, if I remember it. Anyway, we understood very well that those were intentional actions, and these particular type of action could infringe on the rights of different right holders. And then there is another example. There are lots and lots of those at the cassation court. We have quite a lot of those in Paris. A young singer who was just becoming popular with a name, his scenic name, his stage name. He wanted to register his stage name. Was quite attractive sounding, and the producer tried to register it, but registered the stage name of the singer using his own name. So when the producer with that singer quarreled and parted, the producer was the right holder of that particular name, but he was not the producer of that singer any longer. And so that was a truly conflicting situation. So what can we say about the registration of the stage name to the name of the producer, while the name actually belongs not to the producer but to the singer? So we believed that there was a fraudulent attempt, because the producer certainly knew that thus he was getting monopoly over the stage name. And he also must have known that he would not be the producer of that individual forever. And thus he was looking into the future and was actually trying to limit the freedom of that singer at the time of the registration of the trademark.
Donc j'en terminerai par là.
There was already an assumption of the course of action in the future. So the law concerning trademarks keeps developing, and in the years to come, we will come across very interesting cases more and more often, because this enforcement practice is going to expand, and we need to consider all the circumstances in order to protect the rights of the holders, right holders and the third parties. Thank you for your attention.
И спасибо ему за то, что он перекинул мостик к следующему выступлению, к следующей теме. А следующей темой мы хотели поговорить об общеизвестных товарных знаках. И говорить об этом будет человек, чья фамилия сама по себе является
whose name is a well-known trademark.
Доктор Фредерик Мостер.
Frederick
Несколько
Mostert.
слов о докторе
A
Мостере.
few words about Dr. Frederick Mostert. Dr. Mostert
Является профессором
is a
на
professor.
сегодняшний день в колледже
Professor of the St.
Но
Peter's College
до
in
этого
Oxford.
господин Мостер
But
являлся
prior
главным
to that,
юристом
he was the
самой крупной в мире
chief
корпорации,
lawyer
Richmond,
of
которая
the Richmond
производит
Corporation,
luxury goods,
producing
так
luxury
все товарные
goods.
знаки
So
там известные.
all the well-known trademarks are associated
Sharon
with them.
Konstantin,
If
Jacques
Sharon,
Coulter,
Konstantin,
многие
Jacques and many
другие
others,
товарные знаки,
many other
которые и
trademarks
российским судьям, кстати,
that are
хорошо
well known to
известны.
all of us and to Russian judges, among others.
Господин Мостер был
Mr.
президентом
Mostert used to be the president of
Организации
the
товарных знаков ИНТА.
International
Господин Мостер написал книгу,
Organization
которая
of
вот
Trademarks.
сейчас
He wrote a
я
book,
держу в руках,
and I can see that
Так
he's
что
going to introduce
нам
his
очень
book
повезло, что
to
господин
us.
Мостер,
And
профессор
it's
Mostert,
great honor for us
согласился
that
сегодня
Professor Mostert
принять
agreed
участие в нашем
to take
столе.
part in
Пожалуйста,
our
Фредерик.
roundtable discussion today. Frederick, you're welcome.
Thank you very much, Mr. Chairman and Madam President. Ladies and gentlemen, colleagues in the profession, allow me a few words in Russian this morning. Мне очень приятно
Мне очень приятно.
в Петербурге. It is indeed a pleasure to be here. Спасибо. I'd like to talk about something which, before I get into bad faith, that we all know is so true about well-known and famous marks. And it's simply this, that I think it's one of those very fascinating areas of law. As a student, I would always think of international treaties collecting dust on some ancient shelf somewhere, and that it was just a dry area of law. Not so. In practice, I happen to think that particularly Article 6 bis of the Paris Convention is a prime example of where international law is law. It's a living, breathing area of body of law. A type of jus gentium has evolved around this area of law, which I think is absolutely fascinating and so important in practice. And so I'd like to illustrate this because I think well-known marks, and Article 6 bis in particular, is a very provocative and enchanting area of law. And the reason I say this, it crosses all boundaries because we believe that trademark law's traditional principle is that trademarks are territorial. Well, well-known marks are protected across borders internationally in conflict with those rules. And similarly, with famous marks, the whole tradition of the principle of specialty to only protect marks in certain categories in certain areas flies in the face of protecting famous marks across certain categories of goods and services. But commercially, why do we deal with this fascinating area of law, especially in the last 20 years? Well, I can show the globe. This is the globe before 1957. And in 1957, we had the first satellite going around the world, Sputnik. And that was the introduction of the real exposure of trademarks, because in today's world, there are so many communication satellites above our heads. There are, at the last count, over 3,300 satellites above us in the skies, and there really is, according to the experts, a real traffic jam upstairs. But what does that mean to well-known marks? It means that well-known marks get exposed like they have never before. They can become famous overnight. In fact, famous marks are established through the internet, across borders, through magazine spillover advertising. They become truly international at a drop of a hat. And it's this international aspect which I think is interesting to all of us. And dealing with well-known marks, they can essentially be limitless in terms of geography and time. Marks like these become instant almost overnight. But it all started really in dealing with these issues 20 years ago to this year. At the World Intellectual Property headquarters, these were some of the delegates at the General Assembly in Geneva dealing with the first introduction of non-treaty law extension, essentially recommendations or guidelines for the protection of well-known marks. And it was interesting to note that in these days, you can see we all look a little younger in this photograph, but essentially then it was impossible, as it is today, to extend a treaty easily, because what would happen is it would take 20, 30 years for countries to agree. But a very famous colleague of Ms. Van Krienen, Dr. Ludwig Beumer, came up for the first time a new process of introducing national law around the world, which is to adopt country guidelines and then have the WIPO officials go around the world and explain these. And very quickly, countries wanted to adopt and not stay behind. And I'm happy to say that well-known marks are now recognized throughout the world, including in Russia, on a national level because of this. I wanted to show you an example of why I say that the Paris Convention is such a living, breathing document. Well, in the same colleague of ours, Dr. Ludwig Beumer's office, I was sitting one day dealing with a really intricate legal issue. At the time, I was president of the International Trademark Association, and we had to protect President Mandela's name and likeness throughout the world, and it was extremely difficult. He was very concerned that his name should not be misused in a commercial way or in a fraudulent way. Well, to make a long story short, Dr. Beumer and I discussed the application of Article 6 ter of the Paris Convention, which is very similar to Article 6 bis, which deals with the protection of state emblems. And we protected his name and likeness as a state emblem of South Africa. There is the registration document. It's probably the first time and last time an international figure of this stature, his name will be protected in such a way. But it goes across classes and across all goods and services and internationally all members of the Paris Convention. It shows you how live this area of law is. Now, let's deal with the interesting area of bad faith. Bad faith, I discovered before 1995, there were very, very few decisions around the world, most notably only really in Germany, France, and the US, but very few decisions on bad faith in trademark cases, especially well-known mark cases. And the reason was that I would go around the world and talk to judges and to registrars of trademarks around the world, and they would all say to me immediately, when we just have a whiff, when we have a tiny smell of bad faith in a case, that immediately decides the case for us. That's it. We then cast our decision and we give logical reasons. But what determines the case for us, the moment we determine that there is some form of bad faith, that swings the case. But there were very few mentions made of bad faith in the decisions in those days. It was very interesting. At the same time, in 1995, there was this sea change of looking at bad faith. And the question is, what are we dealing with essentially when we talk about bad faith? Bad faith is used quite a lot and loosely. But I think it essentially deals, as Professor Bodenhausen very aptly described this, as the predatory intent of a second comer to use and ride on the coattails of the reputation of usually a well-known mark. And I think one of the best descriptions was by Professor Thomas McCarthy, the famous author, the most cited intellectual property author in the US Supreme Court's history, when he described bad faith, and he refers to this very eloquently. I'd like to just read this passage for you from the book of famous and well-known marks. I'm very happy to say that Eugene Arievich is the contributor for Russia in this book on well-known marks. But Professor McCarthy says essentially, he notes, where there is hard evidence present of the defendant's intent to obtain a free ride on the coattails of the plaintiff's reputation, courts will not refrain from highlighting the underlying equities as evidenced in this quote. Whereas here it plainly appears that there is a purpose to reap where one has not sown, to gather where one has not planted, to build upon the work and reputation of another. The use of the advertising or trade name or distinguishing mark of another, it is in its nature fraudulent and will be enjoined. And then I also have to refer to Judge Strissman from Israel, who made a very interesting and admirable brief comment in the Chanel case when he just said, "Thou shalt not steal," when you deal with bad faith adoption. So essentially, I think it's quite interesting to look at why judges look at the balancing of the different rights, the right of the original trademark owner, usually that has become well known, versus the Johnny-come-lately, who has the better right between these two competing interests. And I think, as our eminent judges here have referred more than once, the evidence to deal with how do you show bad faith is so important for us to present these cases in court. And how does one do that? There are a few guidelines here. There's a whole chapter in the book on famous and well-known marks on bad faith. But essentially, it's distilled from this because the subjective state of mind of the defendant is almost impossible to determine, and it really depends on circumstantial evidence. And it's very interesting to see that one guideline which is developed very regularly with the Uniform Dispute Resolution Policy of domain names, where bad faith, I'm happy to say, was introduced in 1998. I was privileged enough to be one of the panel of experts that determined the rules for the UDRP just before ICANN was formed. And it was very important that we insert bad faith as an element. And we did so. And a number of rules have developed if you look at the decisions that flowed from there. The first one is that if the domain name squatter tries to sell the particular name or mark back to the original trademark owner, the panels defined very quickly that that's an element of bad faith. Or, as President Novosiolova mentioned in the Vermont case, another guideline which courts quite often use is where the defendant knew or must have known of the fame or the well-knownness of the mark, and where there is a substantial similarity between the plaintiff and defendant's marks, as in the Vermont case. A third guideline, which is developed in interpreting circumstantial evidence, is the adoption by the defendant of a foreign language work in the local jurisdiction, or a coincidental adoption of an arbitrary, fanciful, or coined mark, such as Xerox, or Pepsi, or Kodak, or as in the German case that Judge Schoen referred to, the academics case, an unusual word. And this really goes to the heart and the issue of determining bad faith. So often, as you can see there, there's an adoption in a rather unpleasant and tarnishing way. And you can start seeing that this really shows how one deals with these issues. The coincidental adoption, as a famous judge in the UK, Lord Denning, once said in open court, he remarked that the arm of coincidence may be long, but it does not reach to infinity. So these wonderful stories that we hear, these elaborate epics of why someone particularly adopted that unique mark in the circumstances, really determines quite often that there is a presence of bad faith. The question is simply always why? Why did you adopt this particular mark, which goes to the nub of the case? And this is where I think it's quite interesting to pause for one moment to deal with, as Judge Morden so very well in the Canadian case of Orkin decided that you've got to look at the competing interests. And he did remark and said sometimes it depends on the circumstances whether bad faith alone should be a factor in determining a case. And let me put this in context. The Persons case in the US is a classic example and has been used in trade negotiations with China and elsewhere, where US trade reps really take a strong view of protecting well-known marks in other countries on behalf of American companies. And then the issue is back, well, in your home country, the person's case is a classic example where the court did not protect the person's mark. And let me give you the facts. An American citizen was in Japan and saw the use of the person's mark on clothing, adopted, as did in the academic's case, the same stylistic script, the same get-up, the same coloring on a mark. But persons was not registered in the US. It had no reputation in the US. So it's a classic case where there is no kind of background and secondary meaning under US law. And the question was whether bad faith alone as an element is enough. And the court said no. So that's used against the US in the negotiations quite often. Now, in South Africa, when Ms. van Kreuning was previously the registrar, there's a famous case where bad faith in the Burger King case was sufficient to determine that the registrar said bad faith alone, even though there's no registration and no reputation locally, the mere fact that the plaintiff went to America and brought the mark back and first registered here was sufficient to grant the case in the favor of the plaintiff. Similarly, in Argentina, the Vaca Querí case, or the Laughing Cow matter, the mark was cancelled 30 years later, merely on the element of bad faith. But bad faith is a very, very delicate issue to determine on its own, and therefore one has to look at the total of the circumstantial evidence and the facts as a whole before a decision is rendered. And so, on that note of bad faith as a single element, I conclude my remarks. Spasiba.
Большое спасибо, профессор.
Thank you very much, Professor Mostert.
Наконец мы переходим
We're finally moving to the last two presenters and the last topic, which has to do with the Soviet trademarks, which continue to come strong despite some time that has elapsed since the disintegration of the Soviet Union. And we also have not many minutes, not much time left. So I would like the presenters to be very brief and short. I would like to give the floor first to Professor Sergeyev. He's well known. I don't think he needs any introductions. He's one of the leading experts in intellectual property. I don't see if there's any need to open the topic per se, because we can't just have 5 minutes left, and we were told that we need to complete our debates at 12. Let me very briefly talk about my position. The reason why I decided to breach this topic was because 2 years ago I wrote an article which dealt with the ways to resolve the issue of the so-called Soviet trademarks. This is not a term. These are some of the marks and symbols used by the Soviet enterprises producing similar goods. Quite often the symbols were not registered as trademarks, but in the 90s certain producers gained their monopoly rights to use these marks. They tend to become monopolies in that area, prohibiting and barring other producers from using the same marks, same designations. So this is the key issue. There have been a lot of court cases, millions of rubles in damages. However, the problem is still there. And with the creation of the Eurasian Economic Union, this issue may be gaining in importance, because across the countries of that union, different producers seem to have rights to the same trademarks. In my article, I tried to map out some of the possible ways out of this debacle, of this problem, suggesting that some trademark registration can be cancelled on the grounds that these trademarks become common, such as trademarks. Oh, forget about it. Or we could rule registration of such trademarks as bad faith, Or we could we could nationalize those trademarks or rule them collectively owned or collective. Or we could also introduce the right of use, which may be similar to the right of prior use. And weighing all pros and cons, I decided that probably the most realistic solution would be the most latter one, which would be ruling the Soviet trademarks based on the right of prior use, provided, of course, this right can be recognized and enforced. There are two issues important here. The notion of the right of prior use is as arbitrary as the notion of the Soviet trademarks. It's used solely for the convenience purpose. It's similar to the right of prior use, but it's not the same as the right of prior use. So any argument saying that these rights of prior use have only to do with patents then can be overruled. And secondly, the option that I suggest is far from perfect, and its key drawback is that the same means of individualization will apply to different goods which may be different in their quality, and this may lead to the misleading of consumers. A better way could be to introduce a so-called collective use of trademarks, but this could only be enforced given the goodwill of the IP holders who may be having their monopoly rights to those trademarks. As to the prior use, probably we better call it permitted use of trademarks. This option can be implemented given the political will. It doesn't need any significant spending on part of the government. As for the difference in quality and the risk of misleading consumers, these issues could be resolved through various other possible steps. For example, to allow producers to use the Soviet trademarks, provided they have the same quality of product, which would be strictly in line with the Soviet quality standards. But if the products are different but the marks are the same, we need to insist that all the producers use some kind of designations that would allow consumers to differentiate between their goods and to be aware about the origin of the goods. My suggestions were very strongly criticized by some specialists, so it was my purpose to respond to some of this criticism. I don't have the time for all of the critical remarks. I'll concentrate on the most important ones. Some allege that permitted use is counter to the nature of the trademark, which is supposed to be owned by just one producer, but if there is an indefinite circle of such producers, there's no need for the trademark. This argument has no ground because, firstly, it is not clear what sort of infinite group of producers we're talking here about. Those Soviet trademarks could be allowed to be used only by those producers that had access to them in the Soviet times. Their circle is limited, and also trademarks are being widely used not only by the IP holders but also by the licensees, and it has never been an issue for a trademark. And finally, some countries rely on mechanisms similar to that of the prior use, and that does not infringe on the trademark. Those who have their registration, have the priority to registration, they continue using a trademark, and this does not amount a trademark. and the introduction of the permitted use, some allege, it could be going against the interests of the trademark holders who might have invested heavily in the marketing and the promotion and have the rights to royalties. However, this permitted use does not go against all of their interests. Of course, they have the monopoly, but the question is whether this monopoly is limitless, because the original trademark was created under the Soviet times, and many producers were using the same recipes and the same quality and the same products. I think this monopoly was usurped by the trademark holders, and they may be competing in bad faith. As for the royalty, they might have already been paid enough since the time that they have their rights to the trademark. Some critics believe that this may be going against the principle of inviolability of the property, of the private property, and the reversal of privatization. I think this is going a little bit too far with no good grounds. The trademark holders are not being deprived of their rights. They just suggested that they would allow certain room for those producers who traditionally produce the same goods. So nobody's being deprived of their trademarks. They're being slightly limited, restricted in their rights, and this is allowed by Article 12.29. Certain restrictions are allowed. Well, I'm being told that we have exhausted our time. My last argument, I think, is the strongest. The critics allege that you can't allow for compulsory licensing under TRIPS Article 16, which prohibits compulsory licenses. Well, this may seem as a strong point, but this is not so. It's easy to avoid compulsory licensing, but just allow free use of the trademark to those former Soviet producers who used to use the recipes in production before. I'm sure there are other arguments against the criticism. I have to put a stop here, but I'm sure I could talk more about the counter-arguments. Unfortunately, no time. Eugene Arievich, you have exactly 2 minutes to finish off. Good morning, my colleagues. I have no time. I would just want to give you the bullet points. We are opponents to Professor Sergeyev as far as the trademarks are concerned, and we could go on arguing, but what the idea is about is that if someone could have used the Soviet trademark, the same producer could continue using it. So, well, it is a clear idea, but I would like to give you reference to some of the court decisions. For example, these one and these one. A similar case from 2012, and yet another recent case on the Chip Top trademark and domain name. The name was used prior to the registration in good faith, and the court decided that it could be continued to be used. And this is an important decision by the European courts. So if the mark was used in good faith prior to registration, this person could continue using it. Why not apply the same to the Soviet trademark? I think there are a number of political or legal reasons. After 20 years since disintegration, they don't want to rock the boats. But if you look at the Court on Intellectual Rights, they also have a ruling, which I have shown here on the slide. And I apologize, I don't have the time to comment. My dear colleagues, we have to finish this session because Professor Zorkin will be giving his lecture here. Thank you all for your presentations, and you can ask your questions in an informal way. My dear colleagues, dear participants, and our distinguished presenters, thank you very much for having this discussion here. It's great pity we didn't have enough time, but I'm sure you could discuss these very important issues informally. I have a request to all of you, because we will be preparing for the lecture to be given by Professor Zorkin. We would ask you to free the room briefly. In 10 minutes, you can come back to your seats if you want to listen to Professor Zorkin's lecture. Thank you.